Is that Part 4 stand part? This is a debate on clauses 44 to 55. Honourable Trevor Mallard.
Mr Chairman, I think we've now come to the most substantive part of the bill and certainly by far the most contentious. And I'd say, other than with due respect my colleague from the Greens, it is the, from a Labor perspective, it is by far the most contentious and the part which we've undertaken that we will oppose, and our support for the bill depends on the amendment to this being agreed. Part 4 of the bill outlines procedures available in circumstances of urgency. And the nub of what it does, and I will get back to more detail on it, is that it grants to the Minister appointed by the Prime Minister, and in this case almost certainly Mr Macaulay, the ability to override a large number of pieces of legislation of his own accord. It is something that he or she would be able to do. I think describing Mr Macaulay as a sovereign is probably not an appropriate way of putting it. But sir, I just want to say that it is impossible to overstate the anger on this side of the House at this unconstitutional arrangement. Mr Chairman, we have been pushed very hard in Canterbury, and I think there's a debate now whether we were more flexible than we should have been in the granting of powers to the government in this area, and I think, but what is clear is that the powers that go to one minister in this case are much more extensive than they are in the Canterbury situation. And as an example, the decisions of a minister made under Part 4 of this bill are not regulations. There is no requirement to gazette them. They cannot be examined under the order. Well, they can't go to the Regulations Review Committee because they are not regulations. So you can have a decision to set aside a whole body of case law, years and years and years of case law, a decision of an authority that's been specially set up to consider that particular question. It has heard evidence, it's heard the experts, and it makes a decision, and it says no, then the minister can still say yes. And I'll get to some examples here. And I want to make it clear, Mr Chairman, that I'm not that happy about any power to a minister to override a court, a decision or an authority made by a body headed by a judge. My view is that Parliament should have those rights. Parliament should have those rights, but in my opinion, individual ministers should not have them. But I have here offered a compromise to the minister. And the compromise to the minister is that the minister can be a brake on the decisions. That if there is a positive decision made by the authority, which the minister, on the advice of other ministers, decides is wrong, then he or she should have the ability to say, no, we will not proceed with that. That's the compromise. Uncomfortable with the compromise, but that's a compromise that I've put on the table. But, Mr Speaker, the thing that I think makes us look like Nigeria, is a minister who can grant his mates approvals after a judge and a properly formed authority have said no. That's not true. The member was sitting on the committee. It is absolutely true. There can be a hearing. There can be a recommendation on the part of the authority to decline an application, and a minister can override that and can approve that application for one of his friends, for consideration We will never know. But that is the sort of approach that will make New Zealand look like Mr. Chairman.
Honourable Trevor Miller.
Mr. Chairman, this is the most important part of the bill, and one which there will be the most discussion. But, Mr. Chairman, I'm going to be interested in particular in the contribution of John Hayes, who denies that the Minister has the right to overrule the tribunal. He denies the right. Well, it's in the bill, Mr. Hayes. It is in the bill, and the member sat on the Select Committee. He was there for the hearings. He was there for the deliberations. And frankly, if it is the understanding of government members that the Minister does not have that power, then they will have no problem voting for my amendment. If it is their understanding that such a power does not sit in the hands of the Minister, then the appropriate thing for them to do is to vote for my amendment, or in fact, actually, there's a question about whether you need Part 4 at all. Mr. Chairman, what I'd like to do now is to challenge members opposite to give us two examples. Give us just two examples of where they think it is appropriate for a minister to override a decision of the authority. Case-like examples. And I want to say to the former deputy leader of ACT that I am shocked with the position that ACT is taking on this legislation. I am surprised that the party that stands up for property rights allows the property rights of the neighbours to be overruled like this. That there can be a proper application, rejected. Evidence given, rejected. But the Minister says, yes, you can bowl that old villa, that historic place, that building which is subject to a protection order. The Minister can make that decision under this legislation, and the neighbours' property rights are just wiped. They don't have any because of this approach. I must say that I want to thank the Maori Party for the fact that they've looked carefully at this and decided to support the amendment, and quite rightly so, because there could well be marae historic under this. You know, the Minister would have the right to bowl a marae, to dig up a wahi tapu, to put the bulldozers through a burial ground, all of which would be stopped by ordinary law, but the Minister has the right to do that under this legislation because he is not subject to any of the normal laws or any of the normal protections that pertain in this area. And I do want to, Mr. Speaker, just because I know that government members are going to vigorously defend the Minister in this, just to give us an example or two. Two examples of a circumstance. We're not breaching the Select Committee this morning because it was held in public when one of our members asked Mr. Martin Weavers whether security issues could be a reason. Security issues could be dealt with through Mr. McCulley's powers under this legislation, and she was told no. There's a separate process, a proper process, actually involving a judge whose decisions, for many of the things, a judge whose decisions can't be overturned by a politician, and the security issues will be dealt with that way. So I just want to know, why should a minister decide that a house that cannot be demolished under current legislation, it can't be demolished under the Resource Management Act, it can't be demolished under the non-urgent provisions, it can't be demolished under the urgent provisions under a decision from the authority, but a minister claims the right to be able to have that property demolished against all of the evidence. There can be no good reason for that. And I say to